We're now going to look at a pair of cases, Kass v. Kass from New York and AZ versus BZ from Massachusetts. In both of these cases, courts had to decide what could happen with cryogenically frozen embryos left over from infertility treatments after a couple had gotten divorced. The basic story is the same in both cases. In each case, a couple suffered from infertility and decided to use in vitro fertilization in order to try to have children. Before we go any further, it's worth having a basic understanding how in vitro fertilization, or IVF, works. First, doctors collect sperm from a man and eggs from a woman, in the latter case with a minor surgery. Physicians then combine the eggs and sperm, forming what the courts in these opinions call pre-embryos or pre-zygotes. Several days later, some of those pre-zygotes are then implanted into a woman's uterus in hopes of a successful pregnancy. The woman receiving the implant can be the same woman as the egg donor or a surrogate. In our cases, the woman receiving the pre-zygotes was the egg donor, one of the intended parents. Any pre-zygotes that are left over can be cryogenically frozen for later use. Before any of this took place, the two couples in our two cases filled out consent forms where they specified what should happen to any cryogenically frozen embryos should various events occur. For example, if the couples decided they no longer wanted children, or if the couples passed away. In particular, these forms specified what should happen if they separated or got divorced. The Kasses said that the zygotes should be used for scientific research, while AZ and BZ's consent form specified that BZ should get control of cryogenically frozen zygotes. In each case, the ex-wife wishes to use the frozen embryos after the divorce, while the ex-husband does not wish to become a father. In the Kasses case from New York, this goes against the couple's wishes as expressed on their consent form and in an agreement they wrote up at the time of their divorce, which affirmed that the zygotes were to go to scientific research. In AZ versus BZ case, this seems to accord with the wishes that the couple indicated on their medical consent form, and there is no latter documentation. In both cases, the question is, can one parent enforce the medical consent forms against the other? In Kass versus Kass, Stephen Kass is attempting to enforce their agreement that the embryos would go for scientific research against his ex-wife, Maureen Kass, who wishes to try and have them implanted. In AZ versus BZ, BZ wishes to enforce the consent forms against her ex-husband, AZ, in order to get control of the cryogenically frozen vials. In her opinion in Kass versus Kass, Chief Justice Kaye looks at the case like a typical contract case in which the court's goal is to ascertain what the parties agreed to and then to enforce their agreement. Just because they involve a sensitive subject does not mean they should not, quote, generally be presumed valid and binding, unquote, just as other similar agreements are. In fact, the Chief Justice thinks that these sort of, quote, advanced directives, unquote, are especially important in emotionally sensitive domains, such as personal matters of reproductive choice involved in this case, since they can prevent litigation by making it clear what the individuals wanted before the conflict emerged. Written agreements make it possible for courts to seek to honor the parties' expressions of choice made before disputes erupt. The Court of Appeals for New York therefore ruled for the ex-husband and prevented the ex-wife from attempting to become pregnant using the frozen embryos, against the couple's agreement that the embryos would go to research should they get divorced. Justice Cowan, writing for the Supreme Judicial Court of Massachusetts in AZ versus BZ, starts out in the same vein, looking at this as just an ordinary contract. She recites 5 different reasons why the consent forms are likely unenforceable against the ex-husband. The consent form was an agreement between the couple and the clinic but did not say it was meant to form an agreement between the two members of the couple. The consent form do not indicate for how long a period of time they are intended to apply. There is no definition of the term separated in the consent form, so it is not clear when it applies. And on all occasions except the first, the husband signed the consent form while it was still blank, and then the wife filled in all the details, including the instruction that she was to get control of the frozen embryos. The consent form is also not a separation agreement, so it is not enforceable between the ex-husband and the ex-wife. But this is not Justice Cowan's main argument. Even if this agreement were perfectly executed, it would not be enforceable as against public policy. The justices, quote, would not enforce an agreement that would compel one donor to become a parent against his or her will, unquote. Justice Cowan reads other aspects of Massachusetts family law to indicate a general policy by the state legislature that, quote, individuals should not be bound by certain agreements binding them to enter or not enter into familial relationships, unquote. She sees this principle at work in the fact that parents cannot contract in advance to give their children up for adoption, in courts' reluctance to enforce agreements that force surrogate mothers to give up their children they bear, and in their refusal to enforce contracts requiring an individual to abandon a marriage. Justice Cowan here is announcing more than a default rule. An individual cannot, by contract, waive her later decision whether to become a parent. The justice then applies the broad principle that, quote, individuals shall not be compelled to enter into intimate family relationships, and that the law shall not be used as a mechanism for forcing such relationships when they're not desired, unquote, to the case at hand, and finds that the ex-wife cannot use the frozen vials, since that would force her ex-husband to become a father, quote, over his present objections, unquote. The big difference between how the two cases come out, therefore, appears to be that in Kass versus Kass, the agreement would have prevented parenthood, while in AZ versus BZ, the agreement would have forced parenthood on one party. But we can easily imagine arguments for applying the general principle of Kass to AZ and BC as well. AZ and BZ may have thought through very carefully at the time exactly what they wanted and decided ex ante that the best option was for BZ to keep the vials. There's an asymmetry here where courts will protect parties from themselves when they have agreed in advance not to become parents, but not when they have agreed in advance that one will have a right to force a parenthood on the other. So let's go to a quiz. A couple began IVF several years ago, and there are several vials of cryogenically frozen embryos left over. The couple initially specified in their consent form that the husband would get control of the vials if they got divorced. Now the couple has divorced, and the ex-husband wants to have the frozen embryos implanted in a surrogate mother. The ex-wife sues to stop him. For whom would a Massachusetts court rule? The ex-husband or the ex-wife? Well, a Massachusetts court following AZ versus BZ would rule for the ex-wife in this case. The ex-husband's action would make her a parent against her will, and so the consent forms that claim to give him the right to do this are unenforceable. Surrogacy contracts raise similar thorny ethical and public policy questions. These contracts attempt to govern the procreative choices of the surrogate after implantation. Surrogacy provisions routinely give intended parents the right to force surrogates to terminate pregnancies if, quote, a fetus suffers from a serious birth defect, or if a multiple pregnancy occurs where the fetal reduction may be recommended to improve the outcomes for the remaining fetuses. And the surrogacy contracts also routinely contain a related clause that restricts the surrogate's ability to terminate the pregnancy without the intended parent's consent, unless she faces substantial harm from continuing the pregnancy. Should these promises to terminate or not terminate pregnancies ever be enforceable? Should promises to terminate be accorded more weight than promises not to terminate for reasons suggested by the Kass and AZ decisions? Should enforceability turn on whether the surrogate or intended parents would be biological parents? Few scholars think that a court would ever order specific performance of the surrogate's promises, but the possibility of damages is subject to differing views. We have seen two different approaches to frozen embryo cases in the two cases we've discussed. Kass versus Kass treated agreements about embryos as ordinary contracts, where courts should go along with the parties' expressed ex ante wishes. AZ versus BZ, on the other hand, suggested that courts will not enforce all agreements that commit parties to future family relations, because these are against public policy.